Still on the same, the High Court has consolidated over 20 petitions filed across the country seeking to stop the impeachment of Deputy President Rigathi Gachagua. Justice Lawrence Mugambi has said he will on Friday, the 11th of October, give a ruling on whether he will refer the case to the Chief Justice Martha Koome to constitute an uneven number of judges to hear and determine the matter as prayed by the petitioners. As Ruth Wamboi reports, petitioners told the court that the ouster of the Deputy President by the National Assembly does not reflect the will of the people.
The legal battle pitting hosted DP Rigathi Gachagua has kicked off in earnest at the High Court Wednesday with the consolidation of 22 petitions.
We are ready to proceed and get the directions.
DP's lead defense team led by senior counsel Paul Muiti and Elisha Ongoya put up a spirited fight urging Justice Lawrence Mugambi to consider the self-evident urgency of the matter and forward the file to Chief Justice Martha Koome to constitute a 3 to 7 judge bench.
Public participation in terms of the guidelines by the Supreme Court. I am deliberately not going into those guidelines at this stage, just pointing out my lord. We will be saying that the 12 days limitation is in head-on collision with Article 50 of our Constitution.
The court was also told that the case falls under a presidential system of governance and the sovereignty of the people in the process is key.
In determining whether or not a person elected through the universal suffrage can be subjected exclusively to the mercy of the National Assembly.
They also poked holes into how public participation was conducted, citing a lack of substantive legislation on the procedure and whether Parliament should play an active role. The respondents, through counsels Paul Nyamodi and Peter Wanyama, argued the narrative that the Deputy President is elected by the people lacks merit.
The issues that are alive in this matter in respect of public participation call upon you to do is to look at the public participation exercise and perhaps give different directions from Justice Momo. And I submit that it is this court it is the court and the administration of justice that would then be embarrassed if that were to take place.
Well, it would be humanly impossible for the respondents, my lord, to attend to these matters, as some, my lord, fall within the same days and time. That will be even in the interest, my lord, of justice, that then the respondents are not denied a fair trial by the mere multiplicity and duplicity, my lord, of causes of action.
The court was also urged to disregard the petitioner's call for empanelment of a bench, citing the matter can be heard by a single judge.
I see it in the context of a substantial question of law which has not matured. They are scratching it, but it is there. They are scratching it. It can only mature after the Senate has considered the motion that was approved by the National Assembly yesterday for the impeachment of Deputy President of the Republic of Kenya.
Law Society of Kenya has also been enjoined in the case. The lawyers representing the Deputy President Rigathi Gachagua have cited that they have very weighty issues that needs an empanelment of a bench, with the respondents citing that the issues raised by the petitioners are already functus officio. This now calls for the interpretation of the Constitution by the court. Ruth Wamboi reporting for Prime Edition from Milimani's High Court.
Kenyans continue